What I mean by legal pluralism, I can just state very briefly. I take the view that legal pluralism is the situation which exists when a population has more than one law. And a law, for the moment, can be regarded simply as a social normative order. When I say that a population has more than one law, I mean simply that the members of that population observe that law to a certain extent. If we limited ourselves to cases where a law was observed 100%, then we would have nothing to talk about. No law is ever observed to 100%. And I think it may be useful to take account of laws which actually receive rather little observance, because they still have a social significance. As to types of legal pluralism, I would draw a distinction here. There is, first of all, state law pluralism. State law pluralism is a form of pluralism within a particular state law. The significance of this is that the state usually, perhaps invariably in modern times, asserts a conclusive authority to determine what is law within its space. It doesn't always exercise that power, but it certainly asserts that it has the power to determine what is law. State law pluralism within this sphere of state law, then, typically in Africa, of course, refers to on the one hand, the received or perhaps imposed law derived from non-African sources, and the customary laws. And it's customary laws in the plural, because virtually every African state, if not every African state, has a number of customary laws. In most instances, very many different customary laws, which are observed within the confines of their territory. And all this applies to land matters, at least to some extent. The other type of legal pluralism which I would refer to is what has been called deep legal pluralism. This is the type of legal pluralism where the constituent laws, the laws which received some observance in practice socially, are not subject to one overriding authority in the way that state laws are. For our purpose, deep legal pluralism normally consists of state law and then one or more non-state laws, observed customary laws. An important implication, I think, of this distinction is that in the case of deep legal pluralism, there cannot be a decisive, authoritative solution for cases of conflicts of laws, where two or more laws assert jurisdiction, assert authority over a particular issue, because there is no overriding authority in the case of deep legal pluralism. This does not mean that there are bound to be very serious conflicts in instances of deep legal pluralism, which is ubiquitous anyway. It is quite possible for the various laws which constitute deep legal pluralism to withdraw, to give way, to license other laws to operate in certain fields, and so to have a modus vivendi which avoids too many instances where there are competing claims to authority. The consequent types of customary law arising from this distinction between state law pluralism and deep legal pluralism, I think are fairly obvious, and I don't think I need in South Africa to develop this point at length. there are living customary laws and there are official customary laws. Official customary laws are those so-called customary laws which are incorporated into state laws by being recognized by state law. Official customary laws, I would just remark, tend, I think, to be more static than living customary laws, simply because state institutions tend to rely, need probably to rely, on authoritative statements of law which often become quite old. The result is that official customary laws do not often change very rapidly. Now, I want to examine the basis of different types of changes which occur in customary laws, all types of customary laws. First of all, a word about changes which occur in living customary laws, but which are not influenced or not significantly influenced by the modern state. In studying the laws of modern times, it can be quite difficult to separate the various causes for changes in laws, and the state plays a part in many social changes. But I think we must not exaggerate this. Changes in living customary laws are often associated with power struggles within communities where the state is not deeply involved. If we take periods of time before the existence of the state, then obviously changes in customary laws during those periods are not influenced by the state. And as far as we can gather, there have been considerable changes, developments in customary laws in pre-state times. Communities have organized themselves and reorganized themselves in response to the environments in which they found themselves. There have been some instances of communities governed by living customary laws who came into contact with other peoples who observed other customary land laws. The work of Christian Lund is, I think, particularly useful here in his discussion of the relations in certain areas between nomadic communities and agriculturalists, settled communities. There are some instances simply of people copying the customary laws of other peoples, although I'm rather sceptical as to whether that happens very frequently. I would tend to assume that economic forces are rather more important in the transfers of ideas from one community to another. More recently, I think that changes have been attributable, changes in living customary laws have been attributable to forces which we refer to as forces of globalization. For example, the commodification of land arising from global commerce, the use of writing for land transactions arising from the global spread of techniques of writing and reliance on that. But in these more recent instances, it is admittedly difficult to separate the modern state from other causes of changes in customary laws. Next, could I mention changes in living customary laws caused by the very existence of the modern state, the fact that the modern state exists and exercises some power, even though it does not always direct its attention to customary laws. Most obviously, I think, the existence of another power center of the organized by the state has changed power relations within communities in respect of land. The traditional rulers, traditional leaders of customary communities have been considerably affected by the existence of the modern state. One might have expected chiefs to have lost power when the modern state arose? Well, indeed, I think they did, but on the other hand, many have gained power in relation to the remainder of their communities by association with the modern state. The very fact that the state exists changes power relations within communities. But clearly, again, globalization and the effects of globalization are mixed up with the rise of state power in this connection. I would rather spend a little more of the short time available to me to say something about changes in both types of customary laws, living customary laws and official customary laws, caused by state recognition of customary laws. Recognition by the state is either acceptance that customary law is to be applied by existing state institutions, which I would refer to as normative recognition, or acceptance that customary institutions are to become state institutions, although not necessarily to have the same status as existing state institutions. That I would define as institutional recognition. The first effect of any type of state recognition of customary law, which is of importance for our purposes, is, of course, the creation of official customary laws. That is the creation of normative orders within state law which go by the name of customary law, although they may, actually always do, differ from living customary law. There's a lot of evidence in land law as elsewhere. The customary laws as pronounced by state courts and other state institutions differ considerably from customary laws experienced by the peoples, living customary laws discovered by anthropological research when it's well conducted. And I think it's worth considering what are the causes of this, why there is this divergence between living customary law and official customary law. Partly, there are issues of deliberate non-recognition by the state of some aspects of customary laws. The so-called repugnancy clauses are an instance of this. There are also instances where the state institutions simply make mistakes in their endeavour to ascertain customary laws. There are many miscellaneous instances of this. I'm sure that everybody here will know of such instances. But then I would emphasize also there's a divergence between official customary law and living customary law arising from the sheer impossibility of transferring entire fields of living customary laws into the state law context. Essentially, it arises from the point that state institutions, state courts in particular, always adjudicate, at least in the last resort. They may endeavour to use other methods of dealing with issues, but as a last resort, and often it's as a first resort, they adjudicate. So they enforce rules. That means that they operate in terms of rights, because the winner of a dispute in a state court holds a right. The process of winning determines that right. Living customary laws, on the other hand, leave a great deal to negotiation. Or as Sally Falkmore puts it in the title of her leading work on this, law can be seen as, living customary law can be seen as social process. Sally Berry, again, in her book with the interesting title, No Condition is Permanent. I've seen that painted frequently on trucks, passenger trucks in Ghana. No condition is permanent. She also says that negotiability is a pervasive feature of social and economic processes. That means that living customary laws cannot be transferred without change to the adjudicative field of official customary law. In insisting on negotiability, I'm not denying the argument put forward by writers such as Janine Ubink, Pauline Peters, that the exercise of power, especially the exercise of power over land, sometimes negates norms which were previously observed. But I think that that goes to a different point. Apart from negotiability, there is the point that living law changes of itself, whether through the abuse of power or for other reasons. And a result of that is that state institutions, even if they get it right to some extent as to what is living customary law at a certain point in time, are in practice never able to keep up with changes in living customary laws. This is partly because state institutions operate a system of precedent, technical or general, but also because any attempt to keep fully up to date with all developments in living customary laws would be impossibly expensive to do. That, I think, is the main effect of recognition. Other effects of recognition might be mentioned. Recognition of customary law by the state always entails state law pluralism, because the existing received law is never completely superseded. And that existence of state law pluralism means that there must be, whether explicitly or not, bodies of choice of law for determining which law to apply in state institutions in particular circumstances. These often turn, in land law matters, on either the intention of parties who enter into transactions, of individuals who make dispositions, or on the location of the land. But it's, I think, worth investigating these systems of choice of law. I could note also that recognition of customary law often gives rise to codification or restatement, about which some comments have already been made. Essentially, that aims at more rapid recognition of large-scale detail of customary law, which gives rise to all the other problems of recognition, but multiplied because more explicit recognition is attempted by codification or restatement. What is the effect of all this on living customary laws? Well, clearly, official customary laws do not take immediate effect, although they may have some effect. And I think that those effects are worth considering, but we mustn't exaggerate the scope of operation of the state. Just general conclusions then. I would suggest that there are continuing to be considerable changes in living customary laws, mainly as a result of globalization, state law being rather ineffective. That generally seems likely to continue in the immediate future. In the longer term, and I think we should be thinking about the longer term, there is a possibility, I think, of the total disappearance of some distinct living customary laws and their communities, their absorption into other communities. But the further, I think perhaps more significantly, more widespread, the question arises as to whether we can expect unification of these plural laws within states. And I think that the replacement of all plural laws with single laws containing elements of the various constituent laws is simply starry-eyed. It's not likely to happen. It doesn't seem practical. What is possible, however, is movement towards integration. Integration would bring an end to conflicts, to opposition between different laws, even in circumstances of deep legal pluralism, if we work on it. But that will need tolerance, inventiveness by all institutions, all persons and bodies with legal authority.